This is, we will call it the final case of the morning, the estate of Velez versus Shafer. This is a 15-minute mayoral argument on the application. That means you each have 15 minutes. Mr. Roth, you may try and preserve some of that for rebuttal. We hope that you can manage that on your own, and you may proceed when you are ready.
Thank you, Your Honor. May it please the court, Jesse Roth, appearing on behalf of the petitioners. What do all of these cases have in common? Lugo, Perkovic, Mann, and Hoffner. They all stand for the rule that an open and obvious hazard should be evaluated objectively when determining whether one of the two special aspects exceptions to the open and obvious doctrine applies. This court in Mann explained, unlike the Court of Appeals majority decision below, that special aspects are not defined with regard to whether a premises possessor should expect that a particular invitee will not protect against a danger. Rather, as it relates to the unreasonably dangerous exception at issue in this application, the question is whether the particular hazard objectively poses an unreasonable danger to the ordinarily prudent person who is expected to encounter the hazard. A flat, dry roof on a summer day that's only accessible to tradespeople is not an unreasonably dangerous condition and does not fit into this narrow exception to the open and obvious doctrine. In fact, that was the holding in Perkovic, which involved an icy sloped roof on a snowy day. This objective approach to the open and obvious doctrine has been the law in Michigan at least since Lugo, and there's no room in the jurisprudence of this court during the last 2 decades to introduce a subjective standard into the analysis. But just for the sake of argument, here a subjective approach would have to take into account the fact that Mr. Velez was a roofer with 15 years of experience. He was working for a roofer with 30 years of experience. They had worked on dozens of jobs together. This job had them working on a flat, dry roof on a summer day. And Mr. Velez himself was the safety person on the team, meaning he should have been more aware of the hazard than anyone else. But the truth is, all of this really is neither here nor there, because the appellee failed to create a question of fact about whether our Shafer builders even knew what sort of safety precautions the roofers were using, which, even under the appellee's theory of the open and obvious doctrine, would be a necessary predicate to establishing that Shafer had a duty to prevent the fall. The roofing subcontractor Larry Gill testified that there was nothing unusual about the job, but that's no indication as to what Shafer knew or didn't know. There also was testimony that Gill charged less than the average contractor. But again, that didn't create a question of fact about whether Shafer knew what type of safety measures Gill would take. The appellee deposed several representatives of Shafer and had no shortage of opportunities to ask them exactly what they knew about Gill's safety measures. Her failure to ask those questions means the Court of Appeals majority had to resort to speculation about what Shafer knew or didn't know, which means the appellee did not meet her burden. There's also one final issue, that there's no question of fact about whether there even was anything that Shafer could or should have done to prevent the fall. The question is, what does the appellee believe Shafer had a duty to do? Like the court said in Perkovic, the fact that defendant may have additional duties in its role as general contractor, referring to the common work area theory, which is not at issue here, does not alter the nature of the duties owed just by virtue of its ownership of the premises. In other words, whether the property owner is a sophisticated general contractor or a completely unsophisticated homeowner, or anybody in between, the duty owed is the same, because the premises liability theory doesn't care who you are, just that you owned or possessed the property on which the plaintiff was injured. So again, the question is, what does the appellee believe Shafer had a duty to do, or any ordinary homeowner would have had a duty to do if the facts were different, to prevent the fall in this case? Certainly not to go up to the roof and install safety equipment for their experienced tradespeople. Maybe the appellee will argue that Shafer should have warned the roofers to be careful by the edge of the roof, but that also sounds far-fetched, that a landowner would have a duty to warn experienced roofers to be careful about the edge of the roof. And there's also no indication that a warning in this case would have even helped, because there's no evidence of how Mr. Velez fell, without which the appellee can't prove that a warning would somehow have prevented the unfortunate incident. In Perkovic, this court concluded by saying, the plaintiff has not articulated any action that reasonably could be expected of possessors of land in Michigan to protect against the obvious dangers that arise when snow, ice, or frost accumulate on sloped rooftops. To avoid summary disposition on this type of claim, a plaintiff must present evidence of special aspects of the condition that differentiate it from the typical sloped rooftop containing ice, snow, or frost.
Mr. Roth, let me interrupt you and see what questions my colleagues have, okay?
Thank you, Your Honor.
Yeah, absolutely. Justice Cavanagh.
Sure. So setting aside the idea that, the open and obvious nature and the special aspects, that evaluation should be looked at is in terms of the objective nature of the condition itself. And I understand that it can be sometimes easy to sort of blur lines in these where you have the premises owner who is also the general contractor, and they wear different hats for purposes of evaluating the premises claim as opposed to the GC claim and that. But given that, I'm wondering if you can tell me what you think this paragraph from Perkovic suggests. It says, in its status as owner, the defendant had no reason to foresee that the only persons who would be on the premises, various contractors and their employees, would not take appropriate precautions in dealing with the open and obvious conditions of the construction site. There were no special aspects that made this open and obvious condition unreasonably necessary. Do you read that, or tell me why I shouldn't read that statement in Perkovic as suggesting that whether or not the defendant took appropriate precautions or should have known that the contractor wouldn't, why I shouldn't read that as Perkovic saying that is a relevant consideration in determining whether or not there's a special aspect to the roof?
Sure. Well, I think what's very telling is that the Mann decision, which was issued just 2 years after Perkovic and featured all of the same justices who had decided Perkovic, did not see a need to distinguish or even address Perkovic. And Mann clearly says the knowledge of the landowner as to the precautions that the invitee is going to take is not relevant. Also, Hoffner, when it wrote that the analysis is objective and depends only on an evaluation of the condition itself, did not feel the need to distinguish or address Perkovic. I think the only reasonable conclusion is that the justices who wrote the majority opinion in Perkovic did not mean that the landowner's knowledge of the plaintiff's idiosyncrasies is relevant. They just meant that as a matter of law, a roof that's accessible only by tradespeople is not objectively unreasonably dangerous because an ordinary tradesperson will take reasonable safety precautions. I think, Your Honor, it's also noteworthy that former Justice Michael Cavanagh, who frequently dissented in premises liabilities cases, concurred with the decision in Perkovic and stated simply that plaintiff presented no evidence that the icy roof was unreasonably dangerous despite its obviousness, which I think supports our reading of the Perkovic majority.
Okay, so you're saying Mann and Hoffner inform what that statement or paragraph in Perkovic said?
Yes, Your Honor.
Okay, thank you.
Justice Welch.
I have no questions.
Mr. Roth, I have one question. I'm a little bit confused by what work Mann is. I'm not sure why Mann is that relevant. I'm trying to understand what the specific premises claim is here that's been alleged. A premises claim requires that there be an allegation that there's a condition on the land that is unreasonably dangerous. And Michigan's not the only jurisdiction that says a roof is not such a condition because it's open and obvious, right? That's sort of that's the rule, and as far as I can tell, every jurisdiction. I understand the allegations about perhaps the work environment wasn't as safe as it should be, but those to me feel like they're appropriately placed in a common work area exception to the general rule against liability for the general and the owner. And I feel a little bit like the complaints about the work area have bled into the premises claim. What am I missing?
I agree with you, Your Honor, and I think Perkovic makes that exact point that the plaintiff in that case also tried to bleed the claims. It's my understanding that the claim in this case is that the edge of the roof, that beyond the edge had a 20-foot fall, that was the dangerous condition on the premises. Just like Your Honor said, that's an open and obvious. That's clearly open and obvious. That's not unreasonably dangerous. And as Your Honor said, the common work area claims potentially had some teeth here, but those were correctly dismissed and are not at issue in this application. And also potentially a claim against the direct employer, that there was no workers' comp insurance in this case, so there could have been a claim against the direct employer, and that wasn't made, Your Honor.
And I don't mean to be saying that there's never a premises claim that involves a roof. I could imagine, rotted beams under shingles that were not obvious, right? You could imagine shingles themselves that were not attached and therefore slippery. So I guess I didn't mean to be saying no roof ever presents an unreasonable danger without obvious aspects, but I couldn't see in the complaint any allegation about this roof, apart from the allegations about the safety of the work area, that put it in premises claim territory. But it sounds like you agree with that.
I agree with that, and as I was saying, Perkovic concluded its opinion by saying, in order to avoid summary disposition on this type of claim, a plaintiff must present evidence of special aspects of the condition that differentiate it from the typical sloped rooftop with snow, ice, and frost. And in this case, there's no snow, ice, or frost even.
Thank you. Justice Zahra.
Very well presented. I understand your position. I have no questions.
Thank you.
Justice Viviano.
No questions. Thank you, counsel.
Justice Bernstein.
Counsel, thank you. I have no questions.
Justice Clement. No questions. You're muted. You have 3 minutes, a little bit more. You can reserve that time for rebuttal if you like, or you may keep talking.
I'll reserve. Thank you so much.
Okay, Mr. Fishback, you may proceed.
Thank you. May it please the court, George Fishback on behalf of the appellee estate of Joseph Velez. I'd like to address the argument that's been made here that somehow the court in Mann announced an objective test and effectively overruled the restatement, Quinlevin, Riddle, Bertrand, that had preceded it, none of which announced any type of objective test. But I guess before I get to that, I'd like to say that I don't think that's the critical issue in this case. To answer your question, Justice McCormick, we've alleged in this case that the danger that was presented, that Mr. Velez necessarily had to expose himself to, was the exposed unprotected roof edge, and his work, that is the installation of the roof membrane, required the crew, he and the others, to be proximate, literally at the edge of the roof. And that is the specific danger hazard that we're dealing with here. This is a distinct contrast or distinguished from Perkovic. In Perkovic, the work site was not the roof. Perkovic was a painter. Perkovic involved a situation where the owner, general contractor, entered into a contract with a painting contractor. The court says that there was some issue, conflicting evidence, that contract required the plaintiff's employer to provide safety equipment and to ensure its use. There is no such situation here. In this case, we have an owner, a very sophisticated owner, that deliberately chose not to enter into a contract and not to require the gentleman in this case, Mr. Gill, who had no business, no established business, no payroll, no bookkeeping, no nothing. I mean, this is a guy working out of the back of his pickup. And we have an entirely different situation. But more importantly, in Perkovic, the plaintiff was not required to be on the roof. The plaintiff was a painter, painting the side of the house. As we've addressed, as most painters do, trucks have ladders on them. They put a ladder up, they paint the side of the house, and they go about their business. Thus, in Perkovic, there was no evidence that the plaintiff was even required to be on the roof. Thus, when the court held, and I'm quoting directly, for defendant had no reason to foresee that the roof, close quote, was unreasonably dangerous because he wasn't working on the roof. And even if he was, even if he had encountered the roof, the defendant had every reason to believe that the plaintiff would use safety measures because that's what the contract called for. In short, the court found no special aspects. But I'd like to go back for a minute and just,
Let me interrupt you before you go back.
Yes.
To questions, and then if there's more time, you can do that. But I don't want to run out your clock before you have a chance to respond to folks' questions. Justice Cavanagh.
I don't have any questions.
Justice Welch.
I have a question. I'm just wondering about sort of the concern if we are to uphold the Court of Appeals decision about potential liability for every homeowner, for every contractor that comes and does work on their roof. How do you respond to that concern?
That's a good question. And the fact that concern was addressed originally in Bertrand and Riddle, and specifically in Hoffner. And the quote that I read that approves the second restatement, on the other hand, if the risk of harm remains unreasonable despite its obviousness or despite the knowledge of it by the invitee, then the circumstances may be such that the inviter is required to undertake reasonable precautions. The issue then becomes the standard of care and is for the jury to decide. So contrary to Mann, we've had a subjective test that's been the law of this state up until literally Lugo and Mann. Again, I don't think that needs to be thrown out, so to speak, or to decide the case, because in this case, this is not a case involving a mere landowner. Defendant Shafer held himself out as an expert and experienced builder and developer. He had actually subdivided, developed, and then built the entire industrial park, the numerous other buildings where this property was located. He had constructed the original building located on the property. He had constructed almost all of the addition to the building that was being worked on at the time of the incident, including the erection of the structural steel roof supports and the installation of the sheet metal roof decking. In this case, Shafer knew that the installation of the roof membrane required the workers to work right at the exposed edge of the roof. He knew that the exposed, unprotected roof edge was unreasonably dangerous and that he required his own employees to use fall protection safety measures when they worked on the roof. Defendant Shafer, in this case, actually installed the fall protection anchor point, used fall protection during the construction of the roof, and removed that anchor point when they were done. And again, contrary to common practice, he didn't require Mr. Gill to use fall protection at any point in the contracting process or while the work was being performed. There's just simply no evidence of that. In fact, the record evidence has established that defendant chose to disregard the regular practice of entering into contracts with his employees. And based on the price and the circumstances, it can be inferred that he knew that Gill wouldn't use fall protection.
Okay, thank you so much, Mr. Fishback. I'll let my esteemed colleagues continue on with their questions.
Mr. Fishback, facts, as you describe them, obviously are, alarming, but they sound to me like critiques of the general rule that owners and general contractors are not liable for the negligence of their subcontractors or independent contractors. And that's not why we're here today, right? We're here today just on the premises claim. And I don't think I know of, I mean, you tell me, I know there are, as I said before, there are some roofs which might have some conditions that render them unreasonably dangerous. But what are the allegations about this one that make it so?
Well, again, in this case, the roof is at a 20+ foot elevation above pavement. And again, the specific task that the Mr. Gill was hired to perform required him and Mr. Velez to work right at that unprotected work edge. And that, inconsistent with the restatement, Quinlevin, Riddle, Bertrand, presents a foreseeable situation of a unreasonable risk of harm. And I don't,
So I see
under these circumstances, you have to basically ignore the language in Perkovic as to the foreseeability. And I just don't see that as being called for.
I guess let me try again. I don't disagree with you that it's 20 feet around a 20-foot distance to concrete is dangerous. But it doesn't sound like you disagree with me that there was anything about it that was not open and obvious. Are you saying that your view is that the restatement's treatment of open and obvious, restatement second, of course, we're talking about of open and obvious dangers that is somewhat parallel to our special aspects doctrine would have more likely included this particular roof as one that was unreasonably dangerous despite its openness and obviousness? Is that what you're arguing? I think?
Exactly.
Okay.
That in this case, I think that we've established way more than the foreseeability that Mr. Gill would fail to protect the crew. We've shown that was anticipated by virtue of the fact that the defendants chose to set up this entire situation kind of under the table, if you will, avoiding contractual engagement, avoiding an established business, you name it.
But now you're, in my view, wanting to take the facts from the relationship between the sub and the general into bad facts into the premises claim, and I think even the restatement wants us to look at that condition on the land apart from those other issues. But I hear your response, and I appreciate it. It's helpful. I think
I would disagree. I believe the restatement, as well as the special aspects, include the foreseeability that the invitee will fail to protect themselves.
Yeah,
and otherwise that language in Perkovic becomes totally unnecessary. And quite frankly, if the court is to hold otherwise, if the court sees fit to reverse the Court of Appeals here, then it's inescapable that foreseeability of an unreasonable danger is no longer a basis for imposition of premises liability. And I don't see that being warranted. It's a drastic approach. It's not warranted in this case, and certainly not at this time on an application for leave.
No, you've helped me. I understand much better now. I appreciate that. I think I wasn't perfectly understanding that was the claim, and I agree with you about the way the restatement treats a danger that is unreasonably dangerous despite its openness and obviousness. I get it. I thank you very much for your patience. Justice Zahra.
Thank you. No questions.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
No questions.
Justice Clement.
No question.
You have another minute and a half, Mr. Fishback.
I'm going to just quickly sum up. And if we read the line of cases, assuming everyone on this Zoom meeting has, it's been repeatedly pointed out that Lugo it was an unnecessary departure from the restatement from Quinlevin, from Riddle and Bertrand. And it came to be applied as a rule of premises non-liability in cases involving open and obvious dangers. As the courts increasingly use the higher bar, if you will, created by the Lugo special aspects doctrine to justify dismissal of premises liability claims. As you then read through that line of cases, including the myriad Court of Appeals cases, it seems clear what the court wanted to do in Lugo was to objectify what is essentially a subjective inquiry, while attempting to disavow that purpose by repeatedly arguing that the special aspects doctrine is consistent with the restatement, Quinlevin, Riddle, and Bertrand. And again, regardless of which view is correct, the Court of Appeals correctly determined that we presented sufficient evidence on the issue of foreseeability here to go to the jury. And in particular, I want to point out the counsel raised the question, and the answer is specifically, what should the defendant have done? Well, we attached an affidavit of our expert to our summary disposition response that went through, wrote chapter and verse what the defendant should have done. That has kind of fallen by the wayside in the meantime, but that was addressed in this case and is part of the record. Thank you.
Thank you very much, counsel. Mr. Roth, you have some rebuttal time.
Thank you, Your Honor. To make factual clarification, counsel represents that this roofing subcontractor here, Larry Gill, was just a guy working out of the back of his pickup truck. That's not the case, Your Honor. Larry Gill was an extremely experienced roofer, the record shows, having trained and begun working in the field 35 years ago. He had a 7-year-long apprenticeship. He attended workplace safety classes. He'd been a journeyman roofer for 25 years. He testified that he had worked on hundreds of roofing jobs that were similar to this job, and he never had any safety issues. He had been working on jobs with Mr. Velez since the year 2000, and they'd worked on 80 jobs together and never had any issues. And the representation that he was unlicensed, well, as Judge Sawyer said in his Court of Appeals dissent, there's the plaintiff hasn't pointed us to any requirement in the law that a roofer be licensed. So to the extent that any of this is relevant, it's our position that it's not, because again, the analysis is just objective, and we just look at the condition, and we don't worry about the landowner's knowledge, yes or no. But even for the sake of argument, if that knowledge was relevant here, Shafer thought they were hiring a roofer who, had 35 years of roofing experience, never had any safety issues, and had satisfactorily performed roofing work for Shafer in the past. And as I would just follow up on Justice Welch's question about how if we leave the Court of Appeals decision alone, then doesn't that create a duty for all homeowners in Michigan who maybe look up and, I see roofers in my neighborhood all the time. I honestly, do I ever see them using safety equipment? I'm not sure. And if I have those roofers come to my house and they work on my roof and they fall off, and there's a question about whether I Whether I saw that they were up there without safety equipment, I think absolutely, because of the line in Perkovic, that the fact that defendant may have additional duties in its role as general contractor, again referring to common work area duties, does not alter the nature of the duties owed by virtue of its ownership of the premises. So I'm a premises owner, and now I owe duty, and I can be liable if my experienced roofer falls off my roof. Mr. Fishback indicates that there was an affidavit attached to his response to the SD motion in the trial court about what Shafer would have done, but again, those are things that a general contractor should have done, but not things that a homeowner or we're talking about what general duty do landowners in Michigan have in these types of cases, and these are not duties that homeowners should have when they hire contractors to come and do work on their house. If there are any other questions for me, I'm happy to answer them, and otherwise, that's all I have.
Are there any additional questions for Mr. Roth? Thank you both for your arguments, very helpful. And the case will be submitted, and that will conclude today's case call. We will be back in May for our May oral arguments. Thanks all.